2024 at the earliest. Joining me now, former Manhattan Assistant District Attorney and MSNBC legal analyst Catherine Christian. Catherine, thank you very much for coming back to the Saturday show. How likely is it that DA Willis will be able to get her Georgia trial to start on August 5th, 2024?
Unless Donald Trump is on trial with other cases, it should go, meaning that unless the judge says no. So I predict on a case like this where you have multiple defendants in a conspiracy, more defendants will plead guilty by the time August 5th, 2024 arrives. And DA Willis really does not care whether or not it interferes with the presidential election. You know, we're just assuming that Donald Trump will be the nominee. That hasn't happened yet for the Republicans. But criminal defendants throughout this country every day have their lives disrupted. They don't get to have their cases adjourned for long dates because they have a wedding to go to, or they have some other event that's more important, or they have a job. So if you're going to treat Donald Trump like any other criminal defendant and not like the former president of the United States who happens to be a white male and just, you know, give him any time off he wants, then that trial should go. She picked a date that's basically a year after the indictment was announced, and it won't interfere, assuming that the federal election interference case happens in March. And it looks like probably the Judge Cannon Miami classified documents case. Who knows when that will happen? But remember, there's also the Manhattan DA hush money case that can be tried. She picked the date so it wouldn't interfere with those cases.
In an interview with the Washington Post this week, DA Willis said the trial could extend into 2025. Is that a more realistic timetable?
Well, extending means the trial will start in August, and it will take that long to complete it, depending on how many defendants are still left. Remember, right now in Fulton County, there is a RICO case involving gang allegations that has been going on for over a year. It took jury selection months and months and months. So that extension means if the trial does start in August, remember we're talking about extensive jury selection, juror questionnaires because of a high-profile case, pretrial motions, and then the trial will start. So it is realistic for a complex conspiracy multi-defendant case that it will extend beyond 6 months. And if it starts in August, it will go into 2025, assuming that it starts.
All right, Catherine, let's talk about Judge Cannon. By denying a request from the special counsel's office to schedule a routine hearing date in the Mar-a-Lago case until March, is she slow-walking this case?
I think she probably is. If you could compare her with Judge Chunkin on the federal election interference case, who is just like bam, bam, bam. She's like, get the motion in, respond on this time. She comes up with her decisions very quickly. She sets deadlines, moves, which is, for a trial lawyer, that's the type of judge you want, unless, of course, you're representing a client who doesn't want to go to trial. So Judge Cannon on the classified documents case is more of a, you know, slow walking, loosey-goosey, oh, I'm not going to set a deadline, you know, give in your motions when you can. The bad part for the special counsel, that's not anything they can appeal. It's scheduling. She hasn't made any substance decisions because she refuses to set deadlines. So there really aren't any substance decisions. So, yeah, so that case, out of the 4 cases, that will probably be one of the last cases probably to go to trial, unless suddenly Judge Cannon decides, you know what, this is taking too long. I am now going to start setting deadlines.
So, Catherine, the last time you were here, it was before Donald Trump went into court to testify in the case where Judge Engoron is presiding. And I asked you, what happens if Donald Trump acts a fool in the courtroom? And he totally acted a fool in the trial. So I put all that out there for context, because yesterday in the New York fraud trial, Judge Engoron struck down Trump's mistrial motion, calling it, quote, utterly without merit. This acrimonious back and forth between Judge Engoron and Trump, is this going to be a factor on appeal?
Well, it will be a factor on appeal, but what Judge Engoron did, I thought, very well. When Donald Trump acted a fool, at the beginning, the judge was getting upset and was engaging with him, and then suddenly stopped and let Donald Trump just go on and bloviate and say irrelevant things. Why? Because there was not a jury there. There was no jury that you had to protect from hearing prejudicial, irrelevant testimony. In a jury trial, the judge would have to constantly have the jury removed from the room and warn the defendant. And in this case, I think the judge decided, you know what? There's no jury here. I'm the decider. I'm the trier of the facts. I'll let, the defendant go on and on to a limit. And so he can't say on appeal, I was cut down, I wasn't allowed to say what I wanted to say, because the appellate court will look and see what actually the defendant said. And most of it was irrelevant. It was just a puff. He was puffing up his brand, as his kids did when they were called as witnesses on their own case. So the judge very wisely just let him go. There's no jury here. I don't have to worry about the jury. Let him go.
And speaking of letting go, we have to go. Catherine Christian, thank you very much for coming back to the Saturday show.
My pleasure.
And up next, a dire humanitarian warning from the UN as Israeli Defense Forces continue their